right. Hi, everybody. My name is Beth Mulcahy, and I am an attorney with the Mulcahy Law Firm. If anybody has any trouble hearing me tonight, if you can just give me the peace sign like this, I'll know that I need to speak a little louder or I need to speak more clearly into the microphone. Just a few housekeeping items before we get started. How tonight's class is going to run is that I'm going to be presenting on several subjects first, and we have the subjects listed right here. We have community association dispute resolution, so how do you handle disputes that come up between owners and associations, tips for preventing theft and fraud of community association funds. I think that some of you may have already kind of broached this topic a little bit here prior to this evening in another class, but it's a really important class and I wanted to talk about that a little bit tonight. Enforcement of governing documents. So after you hear about how to dissolve disputes, we give you a more practical application of how to handle enforcing your governing documents. And then lastly, collecting delinquent assessments. So we have a lot to cover. I'm going to just make a note that the clock in the room is 10 minutes fast. So just so nobody thinks I'm starting 10 minutes late. We also have on the walls something that we call the parking lot. You'll see them posted on the walls around the room. There are markers adjacent to the parking lot, and we encourage you during our break, which we're going to take at about 7:15, we encourage you to write your questions on the parking lot wall, and then we'll make sure that we address them before the evening's over. So again, I put one question up because somebody asked me right before the class started. They handed me a handout, so I wanted to make sure I put that up there first. That'll probably be the first question that we address. You having trouble hearing? Okay. If anybody's is there any way that I can turn this up, Ruby? Because I don't want to blow everybody out of the room, but I also.
Her name is Ruby when it comes to computers.
Okay, Ruby. No problem. Let's see if we can get it a little bit higher. There we go. I think I figured it out. Is that better? Okay, how's that? Okay. If anybody didn't hear what I said, do you want me to start over? I'll get down a little bit. I come from a really big family, so I'm used to being very loud. Is that good? Good for everybody? Good. Okay, wonderful. Okay, so let's start out. My name is Beth Mulcahy, and I am the managing partner of the Mulcahy Law Firm, and we are located in Phoenix, Arizona. And I have been in business for the past 23 years, and my practice has focused exclusively on representing associations in the state of Arizona. This is all I've done. I started out as a sole practitioner when I was 26 years old, and this is the area that I chose to dedicate my career to. And so I've really enjoyed working with associations over the years. We have about 1,500 associations that my law firm currently represents. We have a team of 18 people that work for our firm, and it's just a pleasure. It's not a job for me. It's truly a labor of love. I love what I do. I love working with associations. It's fun. I love the problems. I love teaching classes like this. So it's a good opportunity for me to get out and provide free education and to talk about emerging trends that are facing associations. So in addition to and one other thing I want to mention is that I'm a native of Milwaukee, Wisconsin. Lived there yay, okay, good. Any Packer fans in the room? Okay, good. I grew up in Milwaukee, Wisconsin, and I went to Marquette University in Milwaukee for undergrad, and I also went to Marquette University Law School for my graduate work. And I also have my master's in business administration with a focus on executive leadership from the University of San Diego. So I have some knowledge obviously from my educational background. I also have served on my board where I live. Most recently, I'm serving currently as the association's treasurer. And I served earlier on in my career on my board, and then I started having a family, and I needed one less board meeting a month. So I got off my board for about a decade, and now I'm back on a board, serving as a treasurer. And when we talked about the theft and prevention of fraud, I can tell you a firsthand experience of what I discovered at my association when I became the treasurer. And let me tell you, it's juicy. So I'll kind of wet your whistle with that to begin with. Again, I said we're going to take a little break at about 7:15, so we'll kind of crank through the first two subjects, and then we'll do our break, and then we'll come back and do enforcement of governing documents, collection of assessments, and then the parking lot. I do teach a lot of classes. I think just in 2017 alone, I've taught over 50 classes for free for board members and homeowners. I have a very relaxed teaching style, which means that you're welcome to answer questions throughout the presentation. If we start to get too far behind, though, I may have to just get us back on track, and you're welcome to stay afterwards, and we're happy to answer any questions afterwards. Or I always do this when I'm teaching a class. If you have any questions, you're welcome to call me at my office tomorrow at no charge, and I'm happy to answer anybody's question. So just one question, though, because I still have to work. So, okay, before I get started, I do like to know who's in the audience, and I see some familiar faces, especially in the back row in the pink. But I like to know how many of you are board members who are currently serving on your board? Show of hands. Okay, great. Thank you for your service. How many of you are former board members? I knew that. I always ask that question now. That's what I was, and then I got back on my board. And how many of you are homeowners who have had no board service yet? Okay, future board members, good. Whether you know it or not yet. Okay, I'm having a little trouble advancing the slide. Is there a special trick on this? Is it just the bar?
The clicker isn't working?
Maybe I'm not pushing the right one. Let's see. I feel like my kid's in an elevator, pushing all the buttons. And while you're saying that, I do kind of have a fun story, Ruby. You probably don't remember this. Maybe you do. How many years have you had this academy?
The spring of 2005. And before the recession, we did it twice a year.
Right.
After the recession, we did it once a year. And you have been here since the second time we gave this class.
Okay, and so that had to have been 2006, right?
No, it was the fall of 2006.
In 6, okay.
No, 2005.
5. Okay, so do you remember the fall of 2006? I came, remember, and I was really pregnant. So I came, I've been teaching this class a long time because my son is now, he's turning 11. And I came to the surprise HOA Academy, and this will show you how dedicated I am to this program. Thank you. And I was 9 months pregnant with my son, and I was teaching, and I wasn't feeling my normal perky self, and I went home that night and I delivered my son that night. At about 1 a.m, I remember I got home and I said to my husband, I just don't feel well, not feeling so great tonight, and we went right over to St. Joe's, and Jack Alardo was born. So, and then 12 months later, Grace Alardo was born. So I had 2 times where I came here where I was very pregnant, and it was actually really funny. One person came to both sessions, and he's like, it's you again? And you're pregnant again? I stopped after that. I have 2 children now. So anyways, okay. Let's get started. I'm Beth, and Lauren's going to be teaching the second half of the class tonight. She's an associate attorney with our firm, and she's a graduate of ASU, and you're going to really enjoy hearing what she has to say about governing documents and enforcing them and collecting assessments. So she'll be here for the second half of the class. Okay, let's talk a little bit about negotiation, right? Everything in life, at some point, you're going to have disputes with people, and you may need to negotiate things when there are disputes. When Ruby and I were planning the class for tonight, and just so you know, there's a lot of planning that goes into these classes. Ruby starts 6-8 months before. We planned this class back in April, right? So we try to come up with what are the most emerging trend topics that are going to be of interest and use to board members and homeowners. And this was a class that we just started teaching this year. And it's really received some great reviews from the one other HOA Academy where I taught it. Basically, what are our legal options when we have a dispute between an association and an owner. And so what we're going to try to do is analyze this and come up with what are the different things that we can do, and what are some strategies for being successful in trying to resolve disputes. Because I'm guessing that I feel this way as a board member for my association. I'm guessing that none of you want to be on Channel 3, right? Being the HOA, the bad HOA, right? The crazy homeowner who's suing the HOA, the bad HOA who's out of control suing the nice homeowner. None of us want that, right? And so when disputes start to escalate, we need some strategies as to how we can work together. And sometimes you can't work together, and we'll talk a little bit about that. What do we do when that happens? Before we get started, we do have an interpreter here tonight that's helping me with sign language. So I'm sure you saw her at the beginning. I'm sorry I didn't introduce you at the beginning. We also are taping the class tonight. One of the objectives or goals of the different HOA academies is to try to get a series of videos that board members can use going forward. So we decided that we would tape the class tonight. Nobody will have their personal, their face or anything in the camera. The camera's right here. And we set it up there so that nobody would feel like any privacy was being violated. So I'm the only one being taped. Okay, let's talk a little bit about negotiation and what are some different negotiation strategies. There are really two types of strategies that we see when we're negotiating disputes. The first one is like a competitive or positional strategy. The second one is what we call an integrative strategy. And there are pros and cons to both. When we're looking at the competitive or positional strategy, that's going to be the hyper-competitive one, right? Which is a high pressure, more confrontational negotiation technique which seeks to establish a clear victory in the negotiation over the opposing party. We really don't use this often in an HOA context because obviously we're neighbors. But there are times where, unfortunately, we do have to do that, typically when the other side is like that. Sometimes you have to hit back hard. And we'll talk about some examples on that in a few slides. The other strategy, which we use more often, is what we call the integrative strategy. And this strategy consists of joint problem solving with the idea that negotiation can result in both parties coming out on top. And that really should be the goal for our industry, right? I mean, of course, there's going to be disputes. When you live in an association, there will be disputes. If you serve on a board, that is something that you unfortunately signed up for. How you handle those disputes will define your association. So if you can take an integrative approach and you can try to come to common ground for everybody, a win-win, where everybody walks away, somewhat happy with the final result, but not totally happy with the final result, you've probably got a pretty good negotiation that you just conducted. Most of the best negotiations will have a wide range of negotiation skills. Sometimes we have to bring out the competitive positional strategy to get somebody more into an integrative settlement. And it just depends on the circumstances that are presented to us when we're negotiating with a homeowner. Okay, what's step one in the negotiation process? Number one, you need to perform an objective evaluation of the situation. And so prior to engaging in a negotiation, you really need to perform an honest assessment of the strengths and weaknesses of your case or the parties involved. People often focus on the weaknesses of the opposing party and overlook their own weaknesses. And that can really hurt you in the negotiation. The more you know about your own weaknesses, the better prepared you can be to address them in a meaningful way when you're in the negotiation. And so one thing I think that's really helpful in step one is getting an outside person to give you some advice. Because lots of times clients, this is what I do for a living. I deal with problems. I deal with conflicts between owners and associations. And sometimes a board, I cannot tell you how many times a day this happens, but it does happen a lot. A board will email me or they'll call me with a problem, and I'm hearing one side of the story. I may be hearing about the homeowner that's doing something that's wrong. Like I have a situation right now in the East Valley where we have a homeowner who has installed artificial turf in their front yard. And they did it without getting approval from the association. And the fact that they installed the artificial turf is not a big, it's not a big deal because artificial turf is allowed. But the fact that they didn't get approval, and then the fact that they needed a special curbing on it per the architectural guidelines, that's what's the problem. So I was talking to the board, and I heard, the position that they didn't get the approval, that they didn't follow the way that it architecturally needed to look with the curbing. And, I'm hearing that this person's not following the rules, et cetera, et cetera. But then we kind of flipped to the other side, and I'm looking at some emails that the owner had sent in, and the owner sent in, pictures of other properties that had done the same thing. And they hadn't put the curbing in. And so the owner was claiming, hey, this is selective enforcement because all these other people have the turf, they don't have the curbing. I don't know if they approved it or didn't approve, I don't know if they submitted an application or not, but mine looks just like theirs and you're coming after me, and why aren't you going after them? And so, the board said to me, do we really have to look at those 5 others? Our association has 3,500 homes. 5 out of 3,500 doesn't seem like that many. And I guess my feeling was, let's pull the file on the other 5s or the files on the other 5 and let's look at what they say. And one of them had been approved without the curbing. One of them was a developer, one that had been approved without the curbing. Another one was, so we had one that the board approved without the curbing, one that the developer approved without the curbing, and 3 other ones that we'd never heard about before, okay? And so my comment back to the board was, okay, we need to address this red flashing light over here of these other properties, and the board didn't really want to hear that. They said, no, we want to address this person, and so it helps to have somebody who's on the outside because I'm thinking ahead. I'm a planner, okay? And I'm thinking if this goes to litigation, I do not want the judge or the jury to see those other 3 properties that we've done nothing on. Why? Because it makes us look bad, right? And the other 2 that have been approved, I can't do anything about those. Those were approved. Just because those were approved doesn't make that provision in the CC&Rs invalid. It just means that there was a waiver granted, right? But those other 3 that we're not doing anything about, that's a problem. So, I advised the board, hey, you need to get those people into your violation status, and we need to find out how long they've been there like this, because after 3 years of the violation existing, we may have lost our right to enforce that. So we had to kind of analyze it. And what they wanted to do is they wanted to just skip the objective assessment and just go right into, let's file a lawsuit against this turf person. And you have to have somebody on the outside who gives good advice, right? Sometimes lawyers have a bad name sometimes, right? Because, some people think that they just, full steam ahead want to sue everybody, and so you want somebody who's objectively going to look at this with a long game approach, not a short game, right? We want to look at this, okay, if this does go further to litigation, we want to set ourselves up so that we've handled it properly. And so step number 1 is going to be do an objective analysis, get somebody in that understands the law and that can look at this and say, okay, here's the pros of your case, here are the cons of your case. Obviously, the pros of this case didn't get approval and they were required to, and then also didn't follow the architectural standards for the artificial turf. The cons are that we've got these 3 other properties that are exactly the same as this person, no approval, no curbing, and then the 2 other properties that did have approval, no curbing, and how does that relate to our issue? Okay, step number 2, engage in a dialogue with the other party or parties. This is another thing that the boards sometimes want to skip. You need to communicate. I tell this to every new person that ever joins our firm. you have to be a good listener to work here. And I'm not talking about listening to me, I'm talking about listening to the boards, listening to the homeowners, giving people a place where they feel that they're being heard. Whenever we're involved in trying to collect a delinquent assessment or there's a violation on a property and the owner takes the time to call in, we drop everything to talk to that person, because that may be my only time I get that person on the phone before this escalates to litigation. So step number 2, talk to the person. Have the parties talk to each other. While some people believe in leading with strength, others listen and defer. There's no one way or another the parties will need to engage in a dialogue. But at each point, each side should be given an opportunity to say their piece, and listen to the other side. And if you've performed the objective evaluation that I suggested in step 1, you should be comfortable with either initiating the dialogue or waiting for the other person to engage in the dialogue. Because we've done the honest assessment in step 1, you kind of know your position, right? Like I can say to the client, let's say the facts changed a little bit on the artificial turf case, and let's say that half of the owners had the artificial turf without the curbing. I would be saying to my client, you're not in a position of strength, okay? Half of your owners have violated this section. I think that this section is unenforceable, right? And so then they would know, listen, we can ask them to get the curbing, but we can't make them, because we lose in court if half of your owners have this violation and you haven't done anything about it. So step number 2, talk to the other side, see if you can come to some sort of a resolution. Step number 3, begin the dance. Once you're engaged in dialogue, the substance of the negotiations will begin. When it comes to negotiations, it's not one size fits all. Styles and methods of negotiation vary from person to person and can also vary based upon the circumstances. However, there are several recommended guidelines that apply to just about any negotiation scenario. Number 1, apply what you've learned. If you completed step number 1, you should be armed with an understanding of the strengths and weaknesses of your position and the other party's position, and you can use that knowledge to your advantage. Number 2, remove your ego. This is the hardest one for boards. Sometimes you may have one board member who there's an ego issue there. They want to be right. They want that person to suffer because they didn't ask for permission. You have to be careful on that, because that may not be acting in the best interest of your association. So the ego sometimes can get the best of us, including me, in certain situations. However, if you learn to remove your ego from the situation, you're much more likely to see the positive end result on this. Yes?
Isn't it also when a board member stands on principle that really they're talking about ego?
Yes. When a board member stands on principle, I can't negotiate at all on this, because it's a principle that our documents say you should seek approval prior to making a change to your property, right? Yes, they should. In a perfect world, people would do that, but we live in an imperfect world. So I guess, how do we dial it back? Can we get them to come to us after it's been installed, which is not ideal, and get them to submit an application then, right? And then try to, once they submit it, maybe we need to say, listen, it's approved, but you need to add curbing. What you don't want to do is just say, denied, right? Because that is going to create a lot of friction. There's ways that you can craft the approval, in such a way that it's a positive. And in that situation, I would say it's, the turf is approved. However, it's approved with the condition that you comply with the architectural guidelines and add the curbing. Live by the golden rule. I cannot tell you how many cases I've been involved in where I've seen bad behavior by both sides, the board and the owner. Show respect for others and conduct yourself in a professional manner. Remember that you are representing not only yourself, but also your board and your community. And I know it's hard. I serve on my board, and we've had people come into the meetings and be really rude to us. And sometimes at the end of the day, when you're tired already from your long workday, and then you have somebody coming in, yelling at you about something that is not really the board, it's not something that's our fault, it's hard not to snap back, right? That's where you have to take a deep breath and, thank them for coming, smile. Usually put a smile on and say, we appreciate your interest in our community. Now that issue is a public street and that isn't something that we're involved in, but you could contact the city of Phoenix and we would suggest you start with the neighborhood services department. Maybe they might be able to point you in the right direction versus that's not ours, getting a real hostile tone with somebody. It makes the interaction really uncomfortable for everybody and also makes that person leave with a bad feeling about your association. Next thing on Begin the Dance, focus on a win-win. In some negotiations, the parties are so focused on seeing the other side lose that they end up losing too. Instead, place your focus on a win-win scenario. I've seen this quite a bit. So where a lot of these HOA cases, they turn into, the issue of the case was, let's give an example. Let's say that the artificial turf case turns into a lawsuit. The issue of the case is the artificial turf, right? And the curbing. And the curbing costs $1,000 to add. Let's just say, I don't know if that's true or not, but let's say it's $1,000 to add. And we end up spending in litigation $75,000, right? And then it becomes, they agree to put the curbing in, but they don't agree to all those attorney's fees. And then the case, guess what, starts to become about the attorney's fees. And, that's where it gets dangerous because judges, you need somebody who's advising your association that can say, listen, objectively look at this and say, the judge may not give us all of our attorney's fees if we continue to pursue this. The judge may say they agreed to put the curbing in. Why are you continuing to fight about this? And I actually had a case last year where, let me think, what was that case about? I remember the attorney from the other side. I did not like him. But we had a situation where, I know what it was. It was, we had an owner, and this is all public record. All these cases are public record, so I can talk about them. But we had an owner that in a condo that installed a washer and dryer, and it was an old condo conversion. Okay, so it was actually an apartment converted into a condo. And the units were never set up with the proper piping to have a washer and dryer. That is not something that they were set up for. The owner installed a washer and dryer. We didn't know about it until the owner below started to have soapy suds backing up into the bathtub, and then sewer water was coming up in the bathtub too. And so we got involved in a disagreement with the owner above. And the case basically, it kind of turned into one of these messes where we went to the city of Phoenix and we had the city of Phoenix shut the washer and dryer down because they hadn't obtained the correct permits. The pipes weren't large enough to accommodate the water flow that was leaving the washer after the cycle had run. And the city of Phoenix inspector came out, issued a code violation, and told them they had to unplug it. And so then they went back and they changed the pipe, and they put the proper electrical in that they should have. And then they came back to the board, and the board said at that point, hey, let's just walk away. We got what we wanted. We're not happy that you installed this without our permission. We're not happy that the owner below threatened to sue us because he was a protected class under the Fair Housing Act, and he felt that he was being discriminated against because we weren't acting as quickly as he needed us to with the soapy suds backing up into his unit. Let's just all walk away. Everybody got what they wanted. Well, no, they didn't want to walk away. They wanted to push this to, keep going on the case. So the case went on a whole year after that. And now the judge is sitting on fee applications from both sides. And somebody's going to win and somebody's going to lose. So, yes?
What kind of court? Do you just appear before a judge, or what kind of legal process does the homeowners go
We're going to cover that in the next slide, so that's a really good lead-in. And so, these type of things where everybody, I want them to lose, that is the mentality of this homeowner in the washer and dryer case. She wants the association to write her a check. And the association is kind of sitting here, they've got insurance coverage. So they're kind of, looking at this like, well, it's not costing us anything, but we also don't really want to be involved in this because we have to disclose it to purchasers who are purchasing and they want to know why we have a lawsuit pending. Be a realist. In most negotiations, neither party will end up getting everything that they want. And if your attorney's saying, okay, we got the owner to submit an application for the turf and they're going to pay for the curbing, maybe we need to write off some attorney's fees as a cost of doing business because we got the end result that we wanted. We did have to file a lawsuit to do it, but if we try to stick it to this person with a hot poker in the corner, the judge may not like it. So you want to listen to your team of advisors and say, the ultimate thing that we wanted was to get this outcome. I think we can settle it if we waive $1,000 in attorney's fees. I think that's probably the way to go because of the uncertainties of the case and whether the judge, will feel sorry for the homeowner. You want to really be real on things. And if you're negotiating it, it may be a good time to listen to somebody who isn't emotionally involved and is going to say, hey, here's the risk. What's your risk tolerance? I say that often to boards, Here's the probability of success, but, it's 60% you're going to win, but what if you're in the 40%? Here's how much that could cost for you if you lose. So
There was a case that came down from the appellate court in Arizona on the 26th, where they cut back on the fees.
yeah, I read that on Thursday. We're going to talk a little bit about that in the enforcement section. And that case is mind-boggling. Actually what happened was they had fined an owner. The Court of Appeals just decided this case. It's like hot off the press. Ruby, you are on it. And so I got the email Thursday morning where I get the automatic email when the Court of Appeals issues a ruling. And basically the association sued an owner for a violation, asked for fines and penalties, asked for their attorney's fees, and the court said that the way that the association did the fines was improper under the law, and they did not give the association their attorney's fees on the appeal, which they didn't say how much they were, but I would guess they're in the $50,000 range. So that case, I don't know if the court decided that right. I gotta be on camera, but I don't know if I agree with that. It's the case. The bottom line of that case was that if you want to fine your owners now, you have to have a fine policy in place. And so we're writing we do a Mulcahy memo every month, and the first week of the month we talk about things that are happening in our industry. If you want to be added to our list, I'm going to leave this red clipboard at the front of the desk, right there on the front of the desk during the break. We'll be talking about that. It's coming out on Tuesday is our next one. Yes?
You mentioned in step one, the order around the artificial grass. You made a comment that it was in place more than 3 years and no action was taken. How does that play out?
Really good question. So when we have violations that have existed for a long time and the board hasn't done anything about them, we waive our right to enforce that as a board. So kind of the golden rule is anything more than 3 years, a violation has existed more than 3 years, that they're going to, if they argue it as their counterpoint, a weakness in our case would be, well, you didn't do anything, and therefore you've waived your right to enforce it. Now, it's not the end-all, be-all argument. I mean, I want to find out when did we discover it. Sometimes we don't discover violations till we trim, brush, and then we're like, oh, when did that guest house go up? So you have to look at, it's a totality of circumstances test, but that will definitely be a defense that will need to be discussed in our weaknesses analysis of the issue. So good question. So any more than 3 years, it could be a problem. Yes?
If you were to do something like that and not just order it and sell the house, does the new owner, would they be responsible for putting that in?
These are great questions. So if we have a sale of a home, and this happens all the time, where owner A sells to owner B, and the association doesn't know about the violation, whether it's the owner installed awnings that are red, and you can only have tan awnings, whatever they are, and then we find out about it after the fact. The violation stays with the lot, so the new owner could potentially have to fix it. There are some different complications because the disclosure laws in Arizona require the association to check their records prior to the sale of a home. Do our records indicate any violations on the lot? And if our records have it and we don't disclose it to the buyer, there's potentially something that they could argue, well, you should have disclosed that to us at the time of sale. The disclosure statement requires you to tell us about this. So we have to really, again, we have to look at the totality of the circumstances on that, but generally speaking, the buyer takes that property with those violations. So, yes?
Even if the association requires that they go in and inspect the property prior to the sale?
Well, the law used to say that. So I've been practicing a long time now. So it used to say that like maybe 18 years ago, the law used to say that as part of the disclosure package, we had to like go out and physically inspect the property and then report back to the buyer. Now it's only our records. So, I mean, of course, if we go out and inspect it and we don't see it, not much we can do about that. But let's say that the manager goes out and inspects it, sees it, and then does nothing. That's going to be an argument that the buyer is going to make when we try to enforce it. Like, why didn't you disclose that to me?
Because our association requires you to have an inspection by the association prior to selling your property.
I think that's a good idea for everybody because as the seller, if there's a problem, you want to know about it before the sale goes through. The buyer wants to know about it before the sale goes through. And from the association's perspective, they just want it fixed, right? So that's a great time to get things fixed. Get money paid and get things fixed at the close of escrow.
A lot of time they miss it until after the fact.
Yes, that is a common problem, that usually comes to me, is that after the fact we determine that, hey, there was a big problem there that didn't get addressed. How do we handle it now? Yes, in the back.
I think the problem a lot of times is not the boards, it's the management company that you hire who goes around checking all this property. And if you're saying these turfs were put in, then, and he didn't see 3 different pieces of property being put in, I think it's a failure of your management property, and you should be looking at your contract with them and maybe get a new management company. Because I think that's where a lot of failures are. I even have a conflict with the city giving permits to put an addition or a structure before, the first thing the city should say to a person, an applicant, is, did you go through your architectural board? Because the city is handing out permits to build things, and then we spot them going up, and we go, and there's the permit on the tree or on the building, and we got a conflict with the city, with the tenant or whoever they're putting in these projects. So there's a lot more than meets the eye that's just putting blame on the boards.
And I agree, that's what keeps me in a job. So, I mean, we've got to navigate all the different competing things that are happening. Did the management company fail to do their job? The city really is separate from the association. They truly are. And so the associations, when you're giving your approvals, you should say subject to obtaining proper permits, from the city. That we should be giving our approvals that way, and then it's up to them to go to the city and get the proper approvals. And if you don't see a permit posted at the property and they need a permit, then the board should be complaining to code enforcement and saying, we think that this is being built without a proper permit.
But I'm also saying that the city should be saying to the applicant, did you go to your architectural board first and get approved before they start handing out permits?
Usually it's on the form. Most cities have it on their form. It's a box that the owner checks before they make the change. I don't know if you have that in Surprise, but in most cities it is on the form. But if the owner's not honest about it, then the city wouldn't know that.
Code enforcement will be here on the last day, and you can ask that question.
Okay, I saw one more hand. Yes.
There's been recently in our community a discussion concerning an action by our HOA whereby they changed our guidelines. Let's say around February, voted on them, the board did. Come March, they ran around taking pictures of all the homes, which were like 600 plus, that had this violation, which is a border on the driveway. And then proceeded in June, when the snowbirds left, to send out letters, June or July, telling them they're in violation and you have so many days to
Fix it.
appeal or to correct it. Now, something like that, and then a lot of these, some homes had permission, had filed applications, some did not, but they're just taking, they just said regardless, we have a new guideline and you don't have an approval on file regardless of when you had it done, even if you could prove when you had it done 5 years ago, 6 years ago, a year ago, they're saying they're in violation. Is this something that?
Are you on your board right now?
No, I'm one of the violators.
Okay. That's okay. That's okay. I mean, if the violation has existed, like I said, for more than 3 years, I think they're really hard pressed to, get that, to enforce that now. The other issue that's raised by that is, they changed their documents. Did they grandfather any of the violators? How much communication was there to the violators regarding the issue?
That's how they did it.
So you have to be really careful on that. Like, I don't know, do any of you remember the case that was all over the news maybe 2 or 3 years ago, where there was an association in the West Valley that said everybody needs to paint their home and you need to do it within it was like a really short time frame. And it was all over the news. It was exploding everywhere. It was not my client, thank goodness. But anyways, it wasn't handled right. And so if you know that you've got people that have a violation and then you change your rules or whatever, your documents to say that they have to, paint their house immediately or whatever you do, get some advice from somebody who's been to war on these things before, because if that client had come to me and said, hey, our association is in need of updating. The colors are all Navajo white. We want to go with some warmer tones. I would say, well, we've done this with a number of other associations. First of all, the color can be kind of a touchy subject. You probably want to go to one of the paint companies and have them do some different color boards, discuss the colors at a meeting, and then come up with a plan to require people to repaint their homes as needed over time. But to go to somebody and say, you need to repaint your home, and there was one person that they interviewed on the news where they had just repainted their home 6 months ago. And we all know what a huge expense it is to paint your home, right? And then they said, we just need you to repaint it the new color now. So repaint it again, and they just painted it. And so, that the way that was handled, it wasn't handled right. That should be on the news, because they should have said, when you repaint your house, then you have to use the approved color tones, and that would have been a much better approach, and you wouldn't have been on the news.
Can boards change a requirement and require that people remove things?
It depends. So, generally speaking, no. Okay, but it really does depend. If there's a restriction in your documents that the board doesn't want in there anymore, the best way to do it, and I don't know what your violation was, but let's say that they say no sheds. They don't want any more sheds. But let's say that the documents didn't say you couldn't have them, so people just assumed they could, and maybe they didn't get approval before they put them in. And then the board decides, we're going to pass an amendment to the CC&Rs to say no more sheds. Your legal counsel should be saying to you, how many people have sheds now? Okay, and how are we going to handle those people that have the violation now? Because I do not feel, as an attorney practicing in this area, that we can do a CC&R amendment that says, no more sheds effective the date that this is recorded. I do not, in my opinion, I do not think it's a good business judgment. I don't think it's a good idea legally to then go after the 10 people that have had a shed. Because some of those people may have had them for a really long time. At the time that they installed it, it wasn't something that was prohibited under the documents. So when you're doing the amendment, factor that in and say any sheds as of the date of the recording of this amendment are grandfathered, so that you're on our grandfather list within 30 days of this passing. You have to provide us with, a picture of it so that we don't get people that put them in after the fact and that say, oh, I was grandfathered type of thing. And so I think all of that should be thought about before you do the amendment. So then you're not in your situation where you're like, what, this was passed, now I can't have it. I thought I used to be able to have it. That will really help you stay out of, that's what I call preventative legal. That's thinking ahead about the problem before it occurs.
In the instance with the shed, is it possible to put in the guidelines that if the house is sold, that upon the sale of the house, the shed will be removed?
Yes, that is one way to handle it. That's not going to be as palatable to the shed owners. You kind of have to get feedback from those people too. They may vote against it, and maybe you need their vote, I don't know. But that is definitely one way. And that's also a really good way to handle, the red awning case, where somebody put up the red awning. I had that case many years ago, and how we actually resolved that case was they painted them. They painted the fabric to match the exterior of the home, and then there was an agreement that when the property sold, that the painted ones would be taken down and that new ones would be installed, or they would be removed altogether. So you have to be creative. That's how, when we were talking on the last slide about, trying to make it a win-win, that's a win-win, because the awnings were painted, you couldn't even tell that they had been red at one point, and the owner didn't have to invest $3,500 and install new awnings, so it just kind of, those type of things can work themselves out if you're reasonable. And I think that's a good strategy. One more question, yes?
Back to the house painting, our board decided that they were going to force us to paint our houses, but they were going to choose who needed to paint their houses by going around the development and saying, you, and you are going to have to paint because of whatever reasons they came up with, they're going to have us paint. Is that?
Well, you have to have some criteria that, so what I would do if you're going to handle the repainting of the homes that way, I would have a list of the people. Usually the board doesn't do that, usually the manager does it. And then I would send those people a letter and then give them an opportunity to be heard and say, if you feel that your home doesn't need to be painted, can you send us the pictures, or can you come to a board meeting so we can talk about it? That is typically how they handle the maintenance things. But even in that case that we talked about, that I mentioned that was all over the news, there were people that showed up and their house did not need to be painted. And they had received painting notices saying their house was in disrepair. So, just be smart when you send out a violation like that you have a place for them to come, in case it's sent in error. Okay, don't take things personally. This is kind of the last negotiation tip. Take the high road. There are going to be times when you're a homeowner or you're a board member where something happens that is wrong, right? That something, you're treated poorly, somebody accuses you of something you didn't do. Just try to always take the high road. Be nice, even when it's hard to be nice, and get over it. One little thing that I left out of my bio for my association was, so I was on my board, I got off my board, and now I'm back on my board. In the time that I was off my board, the board did something that, in my opinion, was illegal. And I, was nice for about a year about it, but then I was like, no, this is not acceptable. You cannot do this. And I tried to get them to change course. They wouldn't change course, so then I had to go legal on them. I did not sue them, but we were a hair away. So I was persona non grata when I got back on my board, right? Because think about it. I had just challenged them on something. They ultimately ended up backing down. The association actually sent a letter about me to all homeowners, which really, It hurt my feelings. I mean, it really did hurt my feelings. And they didn't send it to me, they sent it to my husband. It's like, I mean, you can laugh about it now. At the time, I really almost did cry about it. And, my husband actually sent it to me. He's a lawyer too, and he has a very good sense of humor, and he's very laid back. And he said, I wonder who they're talking about. They gave our address, and they gave a description that I was upset about something. Anyways, I got back on my board, and I got to tell you, I was a little bent out of joint because these people really were not nice to me. But I just had to put it aside, and I had to work with them, and we can laugh about it now. We've got a problem right now on our board, and
Tell them what you found when you got.
well, that's going to be the tips for preventing theft and fraud. That'll be the lead into my next subject. You just have to put it behind you. And we laugh about it now. Like the president at our meeting in October said, we were talking about a problem that we have, and I said, well, I'm really persistent. I'm not going to let this go. We have to fix this. And she goes, yeah, we know. And I laughed. What are you going to do? You could get mad or you can laugh. And I laughed. I go, that's right. Don't forget that. So anyways, you have to be able to let go when you're on the board, whether it's a homeowner that loses it on you or a board member that acts unprofessionally. You have to be able to move on in order to get these positive outcomes.
Beth,
Yes.
if you have a board that's out of control, is there a recall process that's available to those folks?
Of course. You cannot follow what your documents state. You follow what state law states. And how many lots do you have in your association or units? Over 9,000. Okay, so there's two categories for the removal. So if you are 1,000 or fewer units, there's a certain percentage that you need to remove the directors from office. If you're more than 1,000, there's a separate one. So for analysis for you, you have more than 9,000. The procedure to do that is you need to have a petition signed by 10% of your owners or 1,000 owners, whichever is less. And once that petition is submitted to the board checks the names to see if anybody is a non-owner or they're delinquent. Those names get tossed off. You still have to have that 10% or 1,000, whichever is lower. And then the board has to have a removal meeting in 30 days. At the removal meeting, there's a quorum of 20%. And then once you get the quorum, 51% of those who attend in person or by absentee ballot could remove the directors from office. And I have a great handout on our website. So for those of you who know our firm, we do these things called cheat sheets. And we have about 38 different cheat sheets right now. I'm going to come back to you so you can rest your arm, okay? We have about 38 different cheat sheets. We have one called the top 10 things you need to know about association law, and they're all on our website. Our website's in the lower left-hand corner. And number 6 is how to remove directors from office. Are you on YouTube? Because I also taught a class on it, and we have a YouTube, like a video of me explaining the process on YouTube. You just need to go to Google, type in Mulcahy Law Firm and YouTube. And we have 30 classes that we've taught. One of the classes was on removing directors. Okay? Yes?
Just a quick one. You went through the requirements for smaller associations and larger associations, and if they're in arrears and duplicate signatures, you cross them off, and they still have to have a certain number. What happens if there's forged signatures on a petition?
That's I love this class. You guys have great questions.
Ask us, that was a big attorney fee for us in our.
Okay, that's a very easy question to answer. Okay, because I've had cases, I've been doing this 23 years, and so I've been in front of judges where we've had that come up. Unless you bring an affidavit, sworn statement signed by somebody saying, that is not my signature, it's counted. So if you have it has to be a sworn statement saying, I did not sign that, that is not my signature. A judge should look at that and then throw that name out. I also have had people come to the hearings and say, that's not my signature, verbal testimony, sworn statement under oath. But an owner saying, I didn't know what I was signing, or they told me I was signing for the free ice cream, no, that's not going to do it. I've had judges say, no, you should read what you're signing. That's your fault. And so that's an easy question. I've seen that before.
You're suggesting that only that signature be thrown out?
Yes.
The forged one?
Yes.
And everything else stays.
Yes. It doesn't invalidate the entire petition. It invalidates that signature. However, it should raise a flag that where there's smoke, there's usually fire. And so sometimes when I have a board that comes to me in the removal process and they say, we think these signatures were forged, I usually say it's very tough to prove that. The fastest way to do this, because remember, we have 30 days from the time the petition is submitted to us. We have got to hump it to get that meeting done. And so what I say is immediately we spend, usually my team does an all-nighter, and we go through all the names. And I look at everyone that's questionable myself. And then we, if they still think that there's forged signatures, we send a letter to everybody who signed the petition saying, here is a copy of the petition. If you did not sign this or your signature has been forged, you need to contact us immediately. And we give them several different ways to contact us. And honestly, we do like a removal meeting probably once every 2 months. Truly, I've only had that happen a few times, and I've done hundreds of removal meetings. So it's people say it, but it doesn't really, they don't always act on it.
Can a board, for instance, if removal petitions are turned in at a meeting, a board meeting, can the 30 days start after it's accepted? Do you know what I mean? So that it's validated in terms of? It's the date that you get it. That's why you have to move. So, because it could take you a month to accept it. And I think any judge that's looking at this is going to say the date, the time starts clicking, that when you get it. That's why you have to act quickly on those. You can't just put that in the low priority pile. When we get one, we pull possibly an all-nighter, especially if we've got a big association like a 7,000 home one. Okay, thank you.
Yes?
What happens when you send out a petition and you lead people to believe that it's doing one thing, but it's actually doing something different? And you collect the signature.
The
Okay.
issue here, Beth, was the petition that we're all talking about,
Mhm.
had 4 items on it. And generally, with a recall petition, which this ultimately was, it was the second thing on the list. It was the third thing. And we live in an older community, obviously.
People weren't reading?
So something different, which is where.
Yeah.
the experts-
Well, I mean, I would say if you're going to be a person that's passing around a petition for something like this, make it simple. Make the language, simple. I don't like the 4 things on there, but I'm going to tell you, a judge would say they signed it. So we assume that they read it. So, I mean, if you're taking a petition around, you're going to have an easier opportunity in front of a judge if it's clear, if you're not trying to trick anybody, it's going to look better. But having those 4 things on there didn't invalidate it in my mind. I haven't seen what it said. I'm not your lawyer, but.
Thank you.
Understood, yeah, we understand.
Okay, yes. One more question, then we got to get back on track.
If a group wants to do a recall petition, is it smart to consult with someone legal before you start the process?
Yes.
Should you go to the firm that you know advises our group, or should you
No.
go to another firm?
That's the great thing about me. I tell it like it is. Okay, good. Sometimes it's good, sometimes it's bad. No, the attorney for the association represents the entity, the corporation. If somebody contacted me and says, I'm a homeowner, I'm aggrieved by what the board's doing right now, of course, I would want to know that. I would say, put something in writing and I'll forward it to the board, because once you put it in writing, then it triggers my obligation to talk to the board about it. I would say you want to get an attorney that represents homeowners against associations to guide you through the process, especially if you have one of those management companies or one of those boards, or maybe an attorney for the management company or the attorney for the board that is going to be putting up block fences, block walls for you every step of the way. I'm real. If there's homeowners that are submitting a petition to remove the board, and they have the requisite percentage, I always tell my client, you need to look in the mirror. Something's not going right here. Really, we need to talk. What is going on here? Why are people so agitated that they are signing this petition? They need to think, what am I doing here that may not be working, right? But some attorneys see it as, a cash cow, right? Let's fight them every step of the way. Let's make it really expensive for them. That is not how I operate. Looking at what the law says, I'm talking to my client about how did we get here? Where do we go next in terms of what does the law say? What can we, do? What can we not do? But once that petition's submitted, you can't stop it. It's got a life of its own. It's a train in motion. There is no way to stop that. The next step, if you're on the board and you've received a removal petition, is obviously to check the names to make sure they're valid and that they're not delinquent. And then the board needs to start a very aggressive PR campaign. And you need to understand why people are upset and address their needs. A very smart thing to do is to get a communication out right away, stating that you understand people are upset about whatever. We're going to have a town hall meeting before the removal meeting to talk about this and to air grievances. I mean, that's just good PR. Send out letters to people who are out of town, who can't attend. I mean, there's a lot of strategies on that because really the bottom line is no one really wants your job as a board member, right? Truly, they don't. They just want they want to be heard. They want to have you acknowledge that their opinion matters. And maybe we have to agree to disagree. They may want something different than what the board wants to go. But if you hear people out, usually these things can be resolved. But I will tell you, a removal meeting typically costs somewhere between $5,000, and I've seen ones that have gone as high as $100,000. So these are expensive. So if your association is, barely making it, and you get a removal petition, that could break your association, right? So be careful. You want to get advice right away on how to handle that. Yes?
Being that this is so expensive, if I'm outside of the board and I call for the removal of it, and I don't have any funds behind me, if I win that case, or the group with me win the case, then I have the association pay that fee?
Yes. So the loser if any portion of the removal process is challenged, whoever loses that, the judge can award reasonable attorney's fees to, the prevailing party. So yeah, the stakes are high on these cases. You want to make sure you do it right. That's why the owners should have separate counsel. The association should have their own counsel too. Okay, let's get back on track. The next step in the negotiation process is finalize and formalize. If you get an agreement with the owner, you need to get it in writing. Okay, you have to get this in writing. Otherwise, sometimes people get, settlement remorse, and they sleep on it, and they say, oh no, I didn't want to do that. If it's in writing, it's over. Like, we already agreed to that. You can't, back out of it. And then step 5, evaluate and grow. There's going to be experiences that you have when you serve on your board where maybe something didn't go right. Try to learn from it so that you can better handle the situation in the future. I think that's really, really important. Otherwise, you're going to see the same errors again and again. And some of these errors can be costly. So you don't want to have that happen. It starts to affect the finances of your association. Okay, let's talk about what are some alternatives to negotiation. So we always want to try to start out with negotiation, right? Try to work it out with the homeowner if we can. If you can't work it out, there are some different things that you can do. There's 4 main things that you can do: mediation, arbitration. You can go through the administrative law proceedings through the state of Arizona, or last, you can go to litigation. It's the final step. So let's briefly talk about what are these different steps. The first one is mediation. In mediation, what happens is the parties both have to agree. So homeowner and association have to agree, we're going to mediate this dispute. whatever the dispute is. So you need agreement by both sides. An independent mediator who's unrelated to either the owner or the association comes in and tries to mediate the dispute. And how it works is that the mediator listens to both sides. They don't know anything about the case prior to the mediation. They don't know the parties. There's no relationships. They listen to the owner, then they listen to the association. And then they start asking questions. And then maybe they may ask to caucus, meet alone with the owner, or meet alone, caucus alone with the association. And, this is how these things work. The mediator may say to the owner, I know you're really upset. Let's say the issue is unpaid assessments. I know you're really upset that the winter lawn wasn't put in on time this year and you decided to not pay your assessments because of that, but that's really not a valid defense. If this goes in front of Judge Reagan or one of the judges, in court here, he's gonna say, you gotta pay your assessments. It's not a valid defense that the grass wasn't overseeded on time and it can't be overseeded this year. So, and then they'll go over to the association's room and then they'll say something like, this person's really struggling, they're upset about the grass, can we get you to apologize for the grass not being done on time? Can you maybe cut the late fees a little to make it a little more palatable to get a settlement? That's the dance that happens with a mediator. The mediator's looking for everybody to give up a little. The mediator's not gonna make one person, get everything and then the other person, get shoved in a corner with a hot poker. That's not how mediation works. Everybody gives up a little bit and then there's an agreement at some point. Okay, arbitration also requires both parties to agree to arbitrate. So the owner and the association would have to agree to arbitrate. Typically, you bring in a lawyer or a judge to hear the case, and they make a decision. It's not like a mediation where we're trying to negotiate, like, will you waive the late fees? Will you agree to apologize for the winter lawn being late? No, it's not like that. It's like a judge. It's a fast judge. Both sides pay to have an arbitrator, a lawyer, or a judge come in and hear the dispute. We pay that person. The sides split the fees. It's pretty hefty. It's usually about $600 an hour for the judge or the lawyer. And they hear the case, and then at the end they say, I think that the association wins, and here's why. So it's more of an all or nothing proposition. The reason why some people like arbitration is because it's pretty fast. Like, you can have an arbitration, we could get an arbitrator tomorrow and have an arbitration in 30 days. So it limits the amount of attorney's fees that can rack up quickly. But again, both sides would need to agree to that. We don't see very many arbitrations in our practice. We see a lot of mediations where the parties just try to come together with an independent third party. Another alternative that we have is to go to the state of Arizona. They have a program through the Arizona Department of Real Estate where owners and associations can resolve disputes regarding their CC&Rs, regarding state law. And one party files the complaint. It could be the association, could be the owner, against the other party. And there's a filing fee of, I think the filing fees, they change on this website all the time, but I think it's $500 for one issue. And then each additional complaint issue is $500. So if you've got unpaid, or not unpaid assessments, if you have something like a violation, like the turf case that we talked about, and you're gonna file that, it would just be a $500 filing fee. But if you're gonna do the turf case, plus the awnings case as part of one thing against one owner, then it would be $1,000. This is something somewhat new to the Arizona legislature, passed this in 2011. We don't see parties using this very often, but it's also a really great way to have disputes resolved. It's fast. Typically, the cases are decided within 4 months. The total outlay of exposure or cost is going to be the filing fee. So for one issue, that's $500. Attorney's fees are not granted as part of this case, so there's no risk. If you lose and you're the homeowner, like you were talking about up in the top, If you lose a case like on a recall petition, what could happen is, you'd have to pay the association's attorney's fees. That's scary, right? The association is more likely better suited to handle that if they lose than a homeowner would, because they've got the association's bank account, right? So this is a kind of a lower risk type place to have disputes heard. And if you win, the other side would have to pay your filing fee. So it's $500 you could potentially be exposed for. We cannot accept complaints for renters, non-owners, disputes with management companies, unpaid assessments, construction defects. That's not the venue for this. It's only like interpretation of your documents, violations of your documents, violations of state law, removal meetings, that type of thing. And it works. We've had a number of cases in this venue, and the judges are smart, and sometimes the clients don't want to go this avenue because they don't want to not get their attorney's fees back. If they're having me show up, they want to at least have the attorney's fees. Let's see, litigation is the last process. That's just to answer your question. So where can we go to have these disputes heard? If you're involved in an enforcement dispute, it's going to go to Superior Court. It's not going to be handled in Justice Court because Superior Court is the only place that handles the injunctive relief cases where we've got a violation and the court is going to be ordering them to do something. It's kind of the last stop. We're seeing less and less litigation, frankly, because of all these other places you can go. We can mediate the dispute, right? And I think the City of Surprise is going to be partnering with, are you guys going to do the program with the law school?
We already did.
Oh, you already did? Okay, how's it going?
Well, we haven't had cases yet. The parties have accelerated the issues, so they don't want to talk to each other now.
Oh, too bad. Okay, so the City of Surprise is partnering with a law school downtown, and they are bringing in trained mediators to hear these cases. Is there a charge for it, Ruby?
No.
No, it's free. So the hardest part on mediation, though, is you need both sides. So you bring in both sides, the association and the owner, and then these trained mediators from the law school, hear the dispute and try to get you to solve it. So that's a great avenue. And then we talked about the arbitration, but you have to pay the lawyer or the judge on the arbitration. So that can be a little more expensive. We've got the administrative law proceedings through the Department of Real Estate. You've got the outlay of the filing fee, but the judges are smart. They do a good job. They're limited in their scope as to what they can hear disputes about, so you want to be careful that you're not doing a dispute that they don't cover. And then kind of our last stop is litigation. And Lauren from my office, who's now in the back, she is going to be talking about the steps leading up to litigation. Like we send a demand letter, we consider fining. And Lauren, one thing we did talk a little bit about in the class tonight is the fines, the new case on the fines, and about how it's necessary to have the fine policy. So that's so hot off the press, I'm not sure it made that in there. Did we put that in here tonight?
I'm not sure.
I don't think we did, because it just came down. I think we handed this in on Friday. So anyways, those are the different processes for when you have disputes.
All right, we're going to get started.
Hi, everybody. Like Beth mentioned, my name is Lauren Bai. Let's all say bye to Beth. She's leaving. My name is Lauren Bai. I'm an associate attorney with the Mulcahy Law Firm.
Them, not you.
Oh, sure, sorry. I've been with the Mulcahy Law Firm now for almost 2 years. I've exclusively practiced community association law, so I'm very familiar with association issues, problems, all the issues that you guys have to deal with. Before I get started, I'm speaking to the microphone, so that's not an issue. I've been told that there are times when I speak too quickly. If that's the case, just let me know, raise your hand, and I'll slow down. It won't hurt my feelings at all. I want to make sure that everybody... Okay, I'll talk slower. Already happened. So the issue I'm going to discuss with you is enforcement of your governing documents, which, besides managing the money and the funds for the association, is one of the most important jobs of the board. These documents are created specifically to be enforced, to be a covenant between the homeowners and the corporation. So we want to make sure that we're following them appropriately. And I have honestly, since I've started at this job, been shocked at how many boards do not follow their governing documents, and they do not enforce them properly. And it causes problems. If you are a board member that hasn't reviewed your governing documents, you haven't looked into what you need to enforce or how you need to enforce the governing documents, all of a sudden an issue can arise and you can say, well, I've had so many boards say, well, this is the way we've always done it. And our office has to tell them, it's not the way you're supposed to do it, either under your documents or under the law. And it's your job as board members to know. You want to fairly and equitably enforce the documents, make sure that nobody feels that they're being singled out or the documents are only being enforced against them, especially if you do have a homeowner later on who claims that they feel that they're being targeted. That way you can say, actually, the same treatment is given to everybody. Everybody is enforced the exact same way. So like we say, this is a recurring problem in community associations for compliance with the governing documents, either from a violation perspective, landscaping, color of your house, things like that. Also assessments, homeowners that don't pay their assessments on time, that if they are fined, they don't pay the fine, they don't pay late fees. We have a lot of collection files in our office from homeowners, and there are a lot actually that will go for sometimes years at a time, not paying their assessments, no late fees, nothing. And like clockwork, once we file a lawsuit, suddenly all that money is there. They just don't feel like paying them, and they know that eventually when the association, brings it up enough, when they send them enough letters, that they'll pay it in full, that they have all the money. So we're trying to make sure that the association is always getting paid what's owed to it, because it's a nonprofit corporation. This is the only money that it brings in. Your budget is based on a very specific number of assessments that you're going to bring in that year, and you count on that money. So when an owner doesn't remit that payment, that causes problems for everybody else in the community. So we'll go through the steps in the enforcement process. I'm going to talk first about homeowners not complying with like architectural requirements, things of that nature. So under Arizona law, when you send a violation notice, an association is always required to give the owners notice of their right to petition for an administrative hearing. This actually is incorrect. This changed last year. It's not the Department of Fire, Building, and Life Safety. It is actually the Arizona Department of Real Estate. So Beth actually mentioned them in her slide, in her presentation, about conflict resolution. An administrative law judge is the person who will hear your case if you go to the Department of Real Estate. Again, they're very smart. You can get through the process very quickly, but you have to be willing to pay that complaint fee. So again, it's $500 per complaint. So if you have somebody that, let's say, isn't painting their home the proper color, that's $500. And then if you want to bring a separate claim against them to say that they're not mowing their grass or their weeds are out of control, that's another $500. So that's something to think of. And then again, the owner has the opportunity to file a complaint as well. So let's say that you send them a violation letter, you notify them that they have the right to petition in the Department of Real Estate, and then they do. And they file a claim for selective enforcement, they've paid the fee, you still have to appear, the association still has to be a part of the process. So that's one of the reasons you want to make sure homeowners have the right to bring a claim against the association too. So boards need to be very, very certain that they are fairly and equitably enforcing the governing documents and making sure that they're not just focusing on one person who happens to be problematic. You always just want to have the documentation to back up, There are so many owners that will, once you give them a violation, what they'll say is, well, this person has the exact same violation as me and you've done nothing. We get that all the time, and I respond and I say, no, actually just because nothing is being done doesn't mean that they didn't get a letter. It just means that they're not complying just like you are. So maybe both of you should just start complying with the documents. So when a violation occurs, we always recommend sending a courtesy letter. Your governing documents or your rules and regulations might actually require you to send a courtesy letter. Basically, you don't find the owner yet or anything like that. You just let them know, hey, this is a violation. This is the provision of the governing documents, the rules and regulations, whatever it is that it's violating. And you have 14, 10, however many days to correct the violation. It's nice, it's neighborly, it helps somebody, there are a lot of people who actually are in violation of the governing documents and have no idea. I think you would all be absolutely shocked to realize how many homeowners purchase homes or condominiums and they never read their governing documents. They're just excited to get their home. They don't know what rules they're agreeing to. They don't know what they're supposed to do. So this is a really nice, friendly way to let somebody address the problem without worrying about a fine, without having the board breathing down their neck. A lot of homeowners really will take care of an issue right away when they get that letter. Some will claim that they didn't get it, and if they don't, you can move on to our next step, which is you can send a formal violation letter. In a formal violation letter, we make sure that we list, obviously, the violation, and you want to always list the provision of the governing documents that it's violating. Always be able to back it up. And one thing that we have seen boards do is they'll make a decision at a board meeting, and they'll say, okay, we've passed a resolution, now your grass has to be reseeded every 6 months or something like that. And then homeowners, it's not written down anywhere, it's just passed at a board meeting, and they start sending out violation letters when 6 months rolls around because people aren't reseeding their grass. You can't hold homeowners responsible for that. They need to be able to see the rules. They need to be able to know what they're supposed to be held responsible for. So make sure you're citing to an actual provision in your governing documents, so that way you can back it up. You can let the owner know, this is what you are in violation of. This is the authority that we have to let you know that you're in violation of that. Please correct it in the next 14 days. This letter should contain the date of the violation when it was first noticed, and if the violation is continuing, then it should include the date the property was last inspected. Make sure that you notify all of that, because you'll have a lot of homeowners that will call and claim, well, this is a really old picture, or it's been corrected. And I've had it go both ways, where the board didn't take the time, or the manager didn't take the time to go look at the property again, and they were wrong, and the violation was corrected, or boards just assumed that the owner was right, and the violation actually had never been corrected. So take the time, make sure that you have the last date the property was inspected, make sure it's close to the date that you send out the letter. That's just common sense. And then the formal violation letter also must set out the process the member must follow to contest the notice, so the appeals process. If they just appeal to the board, if they appeal to an architectural review committee, again, you need to notify them and let them know that they have the ability to petition in the Department of Real Estate, but let them know. And then the letter should give the owner the opportunity to request a meeting with the board and provide the owner with the name, phone number, and email and address of the person to be contacted by the owner if in violation. So give them all the information to try to correct the problem, to try to remedy the situation. It's just helpful and, again, neighborly. Fines. So fines are actually a pretty tricky subject. How many people here have trouble, how many boards have trouble collecting fines? None of you? Nobody? Okay, there's one person. Normally they're pretty hard because usually if somebody has actually had a violation or whatever the issue is, normally once they correct it, they feel like, well, I've corrected the violation, that's what you really wanted, I don't want to pay the fines, which to their credit, that's pretty true. The association really did just want whatever the violation was, they wanted it corrected. But suddenly, you rack up $250 in fines, and the association has the right to do that, and the homeowner definitely owes that money. So under Section 33-1803 of the Arizona State Legislature, so after notice of the violation, you can set forth the formal violation letter, the opportunity to be heard. The association, through its board of directors, can impose reasonable monetary penalties on the owner in violation of the governing documents. So what that means, and I think Beth mentioned our recent case that we just heard on Friday from the Arizona Court of Appeals, is that associations now need to make sure that their fines are in a fee schedule. So you need to list out what fines you're going to implement for each violation. A lot of your associations probably already have a fee schedule or something similar to it that says for a first violation, a homeowner's charged $25, then it's $50, then it's $75, then it's $100. It might be less than that, it might be more than that. We see that a lot. That's very common. It's also very common to give an owner 14 days to correct a violation. Usually I've seen them stay at that 14-day schedule. It just gives somebody enough time because sometimes it is a very easy violation to correct. Sometimes all you need to correct is mow your lawn, weed, something like that. Sometimes it's painting your house, or it's taking down a structure that they've put up and it's unreasonable to expect the owner to remove it in 14 days. So that's a pretty standard timeline that we see, but you're not required to have a certain timeline. Just make sure that it's a reasonable amount of time. So what the association can do to try to enforce payment of the fines is filing a lawsuit against the owner. You can obtain a judgment against the owner, and then you can record the judgment with the county recorder's office. This puts others on notice when they look up this owner that they owe money to the association, and that, let's say they want to sell the property, that those amounts need to be paid in order for the new owner to receive clear title. Judgments for fines can be tricky. I will be honest with you and let you know that judges do not like them. They know that the association doesn't factor fines into their budget. They know that it's just because somebody didn't weed their lawn or something. It could be something more serious, but they know that it's just punitive to try to get somebody to comply with the governing documents. So we see a lot of courts, if there are a lot of fines, we see them cut them. So we like to include it. You can include it in an injunctive relief lawsuit that Beth said would go to Superior Court. If you're trying to correct the violation and get the fines paid, you're much more likely to be awarded all of your fines. A lawsuit for just fines alone, we might recommend that you make sure the owner also owes assessments, or if they owe late fees, if they owe administrative costs to the association. We try to include those in there because sometimes judges, especially the justice court judges, they just don't like lawsuits that are only for fines, and they will probably cut it. And then the association, has put in all this time and effort and hired an attorney to try to collect these amounts, and then your amounts are cut. So consider that before that happens. If you want to do an injunctive relief lawsuit like Beth mentioned, that's going to go to the Superior Court. Those the judges take pretty seriously. They review, they look at the documents. They consider, okay, is the association being reasonable? Is the homeowner being reasonable? Are they just being stubborn? We've had cases where actually, I think it was in this area, there was a homeowner who was renting out their property and just didn't cut their grass. The tenants didn't cut their grass, the owners didn't cut their grass for years. It got so high that we had to call the city and report them. We had to let them know that this person actually was creating a fire hazard, and they were. So once the city reached out to the owners, they were a lot more responsive to getting things figured out and getting the grass taken care of. But we were several years into fines, and they ended up getting, I think it was like maybe the court awarded them maybe $7,000 in fines and had no problem with it because this owner clearly did not care, clearly did not want to take care of their area, and they created a fire hazard. So it's not necessarily that courts are always worried about fines, that they're always hesitant to award them. It's really more so on a case-by-case basis, and it's something that the board should keep in mind if they do decide to file a lawsuit. Just keep in mind, these could get cut, but we're going to hopefully not have them cut. Anyway, so with recording a judgment, after the judgment is recorded, the association has a lien that's effective upon conveyance. So if they try to sell their property, if it ends up passing through a intestate, then suddenly somebody notices, hey, there's amounts owed to the association. Those need to be paid before title is transferred. The association also can proceed with collection of the judgment through traditional means, so like a bank, a wage, a rent garnishment. We'll talk about that more in depth a little later with our assessment collection. Under the Condo Act, associations no longer have the right to record a lien for unpaid fines, penalties, late fees, and charges on fines. So that's something we need to be careful of. It's different to record a judgment lien. We can't just file a lien for fines. They just can't be a part of it. It's a pretty hefty price tag if an association does file a lien for fines. We know there are a lot of associations that sometimes that are smaller that try to file liens on their own to save themselves money. Our office just cautions that you need to be very careful when you do file those liens. You need to make sure there are no fines or costs involved with fines involved, because if the owner does find out and if they do claim that you filed what's called a false lien, that can cost the association a lot of money and a huge headache. So just be aware of that if you do file your own liens. If a management company files them for you, they should know as well. Our offices knows, and we go through and we eliminate any cost that we see that could possibly be associated with a fine. So self-help. This is something that's going to be in your governing documents. It will let you know if the association has the ability to act in its own interest and remedy the situation on their own. So if the owner fails to correct the violation in a timely manner, again, some of the documents allow them to correct the violation on the lot or unit. Obviously, it's never going to let you go inside someone's house, and you don't want the liability of going into somebody's house without their permission. If your governing documents do allow self-help, really read through the provision. If you're uncertain about it, give it to your attorney, give it to our office, give it to the manager of your association. Some of them are actually kind of specific about how the association can go about engaging in self-help. If they need to notify the homeowner actually and let them know. Some require a letter that says we're going to enter onto your property at this time and trim these hedges, or we're going to move your trash can, something like that. So make sure you look at the actual provision. You don't just barge into somebody's yard and start mowing and then they get upset with you. We say there, specifically follow the procedures outlined in the governing documents. It's recommended the association provide the owner with the date on which the work will be done, and the person who's doing the work, the expected time that the person will enter the lot. This is just to kind of save the association the headache and potential problems or liabilities down the road. As a homeowner, if you had somebody coming onto your lot and potentially changing your landscaping or moving something, you'd be upset too if someone just appeared. To help the association, even if your governing documents don't necessarily require you to provide notice, sometimes that is the best route, just to protect the association and say, hey, you as a homeowner have received this many violation letters, so you've known about this violation for a while. We finally got to the point where we're going to take care of it ourselves, and you had notice of that too. We've given you every opportunity to correct this violation, and you failed to do so. That makes the association look reasonable, like they're just trying to correct the problem and it's not punitive. They're not trying to upset a homeowner or punish a homeowner. Again, it really protects the association in the long run. And then, while an association can use self-help if authorized in the governing documents, you can't breach the peace. So if somebody is trying to stop you from going onto your property, don't try to barge onto the property. Don't try to create a scene. Don't create problems. Again, it will just create problems for the association down the road. If the owner confronts the worker who enters his or her property, we have had this happen before where owners have gotten, abusive, almost violent to somebody trying to enter their property. And in the long run, that's just not worth it. If anybody feels unsafe, if they feel like they shouldn't be in that situation, it's just not worth it to correct somebody's violation. So get out of that situation and make sure that whoever you have doing it, a board member, somebody that you've hired to help take care of the situation, remove them from it. It's just not worth it. And then you can move forward with other legal remedies. If you've tried self-help and it hasn't worked, we can move down the lawsuit route or something like that. Before I move on to delinquent assessments, does anybody have any questions regarding fines and violations? Oh wow, you're one of the first. Usually everybody's got a violation story. Oh yes.
I guess I have a question about what was in the first slide that says that you send a courtesy letter or post a notice on the property. Would somebody really do that?
You know, it's a lot more common to send a courtesy letter. That's usually what we see. Posting something on the property can sometimes feel a little bit aggressive, I think.
Yeah, well, that's what I thought too, and I was surprised it would be part of the initial.
Yeah, you know, it really depends. Very few do operate that way. Like I said, normally you send a letter. It really just depends on how you want to do things, but the letter's usually safest. And you can be certain at least that the letter has been sent and that it's very likely been received, where somebody's going to claim that they didn't see something posted or whatever, they're going to claim.
Like a great big sign in your front yard that says bad people.
That's the thing, it's kind of antagonizing, and especially if it's a fine, you have to kind of think, okay, is this worth the fight? Are these weeds worth creating this problem with this homeowner? Because I was actually dealing with an issue recently for one of our associations where this owner is just absolutely up in arms about this. He didn't follow the rules, he didn't submit an architectural request, but he is contacting ABC 15 almost every day. He is emailing me, he's calling the board, he is just up in arms about the way that they're handling it. And it's just not worth the headache. It really is. It's just so many problems. Are there any other questions? Oh, yes.
Well, you're saying send a letter of posting. The city of Surprise posts violations. They had a palm tree violation. If your palm tree's in violation, the inspector hangs the thing right on your door. So why is the city you kind of recommend that homeowners don't do it, but the city can do it?
That's true. So the city can do it. I'm just letting you know what common practices are. Normally, homeowners associations send out letters, especially if you're dealing with a homeowner that doesn't actually live in the community. We have a lot of communities where the owners are landlords, they don't actually live there. And the tenants, while they may be the people that are causing the violation, they're ultimately not responsible for it. The contract and the agreement is between the association and the homeowner. So the homeowner is the one that's going to pay the fines. They're the one that needs to correct the violation. So you want to make sure it gets to the right party. You're right, you can if you want to. Normally, most governing documents or most associations send letter. That is the common practice. But you're free to do whatever you want so long as your governing documents allow it. And then you had a question too.
Okay, our community has a secret weapon. We have transponders that you don't have to go through the gate with the person to let you in. You can open it yourself and
Okay.
go in different areas. And if they don't pay their fines or they have violations, the transponder can be turned off. And they'd rather pay the money, they would rather pay the fine than have their transponder turned off. That's the worst thing that can happen to you on a vendor's day when you're 50 cars out.
Right.
And you can't use the transponder. So that works real well.
That actually is something that a lot of people should check their governing documents for, where if somebody doesn't pay their assessments or they're in violation of the governing documents, a lot of your documents will give you the right to revoke some of their privileges as owners. Sometimes they're not allowed to vote in elections for board members or any kind of other vote that's taking place. We have some that can revoke access to a key fob that lets them into the pool. They can't use any of the common areas. You want to check your governing documents for that. It's actually pretty effective because they are things that homeowners do certainly feel that they are have an absolute right to the pool. They have an absolute right to that, to a key fob. And when they find out that they don't, suddenly that money appears pretty quickly when their grandkids come and they want to go to the pool, or they're just used to being at the pool all the time. So that's a great note, and that's something that if you are looking for another remedy, that's a great remedy. If you have it. If you don't have it in your governing documents, don't try it. That could end poorly. So collecting delinquent assessments, this is something that our office does quite often. Unfortunately, there were a lot of people after 2008 that got behind on their HOA assessments. It really came down to when people had a pile of bills each month and they spread them out, the association was the last person they were going to pay. So some people have incurred some pretty hefty assessments, some pretty hefty late fees, attorney's fees, things like that. Some, like I said, just don't pay. They can go for a couple of years without paying. It doesn't bother them. They have no problem with it. Sometimes their board just doesn't act on it, and suddenly they're a couple thousand in, and they come to our office, and we say, why didn't you file a lien a long time ago, or why didn't you act on this a long time ago? Now this person owes so much more, and it's harder to collect. We do have ways to deal with that, but it's something that, be aware and be kind of vigilant about amounts owed. The assessments are something that you factor into your budget every single year. The association relies on that money. So when you have owners that feel like they can get away with not paying assessments, especially if they can, that causes problems for the association down the road, and then you have to expend money possibly to try to collect those assessments. It's just something that the association has to go through a process before they can recoup that money later on. It's a very common problem. Pretty much every association has it. If you don't, you are a very, very fortunate association, and good for you, and I want to talk to you afterwards and figure out what you're doing right. So most associations start the collection process by sending late notices. They impose late fees. They can record a lien against the lot, which is very, very common. However, if they are unsuccessful, you may consider taking legal action to enforce the association's rights. So under the CC&Rs, the board usually has two options to collect. They can obtain a personal judgment, or they can foreclose against their lien on the lot. A personal judgment against an owner in justice court. So basically what happens then is you want to make sure that you've notified the owner that they do owe these amounts, that you sent them a letter, you let them know, but don't let it get too far down the road. I've seen associations that have sent us files, and I mean, they've sent maybe like 15 letters to the owner trying to get them to pay. And we look at that and we say, okay, so clearly this was a strategy that wasn't working, but the association paid their management company to try to collect this amount, and it's not working, and now you have all the administrative costs that the association has paid their management company. Sometimes it's $25 a letter, sometimes it's more than that, and you're just a couple years into it and nothing's been collected. It just doesn't make sense. So our office or your attorney, whoever it is, can file a lawsuit in justice court. The justice court's actually right over here. I'm here all the time for a lot of our associations for collection issues. So what this is the association's going to obtain a judgment against a delinquent owner, and once they have that judgment, you can garnish the owner's wages. So we find out where they work and we garnish their wages. That's one of the most effective ways to collect. You can garnish their bank account if the owner has paid in the past, which hopefully they have, and you have some bank account information. State law allows us to garnish their bank account. If it's a joint bank account, I believe we have to leave about $600 in the account. If it's a single bank account, I believe we can leave about $300. The only thing that we also need to watch out for with bank accounts is when somebody has no money in their bank account. So think about that. If it's somebody that really doesn't have a lot of money and there isn't a good chance of them having a lot in their bank account, you need to consider, okay, is this a viable option for us? Or if there's somebody that has that owes child support always takes precedent. If they're trying to garnish a bank account, don't try. Child support comes first, always. Or we can do, so basically a rental garnishment. If it's somebody who rents the property or they rent another property that you know of, basically we initiate a garnishment where we contact the tenant and we let them know your rental payment no longer goes to your landlord, it goes to the association. And then you receive that until the judgment amount is paid. They're pretty effective, always a good idea. We can also do what's called a judgment debtors exam, which is where we contact the owner, we ask them for personal information, we ask them for their bank account, we ask them for their employment information, their spouse's employment information if we also have a judgment against a spouse. And we ask them for that information, and they're required to give it to us under law. It's effective to try to get our information with the intention of eventually garnishing a bank account, a wage, rent, whatever that is. So benefits in justice court, it is relatively fast means of obtaining a judgment. Once you have filed a lawsuit and served the owner, normally owners don't really evade that much. They get served pretty easily. We only have some people who really, really evade, and in that case, we would go to the court and we ask them, if we can serve by alternative service, which is where we can post it to their property. That's what we do. If we know the owner is evading, we know they're in the house, we can hear dogs barking, there are lights inside, but they never answer. Or we can do what's called service by publication, which is where basically we don't know where the owner is, they've taken off, but the association still has a right to file a lawsuit. So we basically have to post that we're going to file a lawsuit against this person for 4 weeks in the Arizona Business Gazette, and then once those 4 weeks are done, that owner needs to contact us or we can move forward. But once that 30 days, the owner gets 20 days after they are served to file an answer. We have a lot of owners that honestly never file an answer. The idea of a lawsuit really, really intimidates them, or they've been trying to avoid payment for so long that they're not going to contact us now. If they don't file an answer, if they don't respond to the lawsuit, the association can proceed to obtain what we call a default judgment, which means that somebody hasn't responded. The association doesn't need to wait forever for somebody to realize they're being sued. We go to the court, we say this person hasn't filed an answer, we need to proceed with a judgment. Under the law, after 10 days pass after we file those notices of default, the association automatically is granted judgment. So you get an automatic judgment, which is fantastic, because usually somebody is simply just not contacting the association, they're not answering the lawsuit. Let's say that that's the case and we still have somebody's employment information, we get a default judgment, we move forward with garnishing their wages. It's that easy. So it is a relatively fast process, especially if the association can obtain a default judgment. If somebody answers, the process can be a little bit more drawn out, but like I said, more often than not, we actually don't really have homeowners answer. Since the economy has been getting better, we have had homeowners respond, not answer, but respond to the lawsuit right away and say, okay, I didn't know that the association was at the point where they were going to file a lawsuit against me. Let's get this figured out and settled. We have a lot of people that are also a lot more responsive to liens. The first year I was working at the firm, people did not answer liens. Suddenly this year there's this big uptick where when somebody finds out that a lien is on their property, whether they're trying to refinance their home, whether they're trying to sell their home or another home, they panic because it shows up on your credit. And so they start to panic and they call and they want it taken care of right away. And you gotta give credit to the credit bureaus. They find those liens fast. It shows up on your credit really fast. I'm impressed. So they contact us pretty quickly and they try to get it taken care of. A lien has become much, much more effective in collecting amounts, and I recommend them to associations. If the judgment may not be collectible if the owner has no assets. Like I said, with the example of the bank garnishment, we need to be smart about how we're trying to collect from somebody. If it's somebody that we know is having trouble with the association, money, if we know that they don't have a lot of income coming in or something like that, or we know they're trying to pay off amounts owed on their mortgage or something else, we need to be smart about that and say, okay, we're not going to try to, garnish a bank account because there probably isn't going to be anything there. So we need to be aware of what somebody has and what somebody doesn't have. If a debtor files for bankruptcy, so there's a chance that the debtor will be discharged from the entire debt, which means that the association can't collect on any of it. And the proceedings and efforts to collect the debt will be halted due to what's called an automatic stay. When somebody files bankruptcy, the purpose of it is to try to give the debtor a chance to breathe and a chance to figure out their finances. So all collection efforts have to stop. Normally when people file bankruptcy, it is for good reason. They do need to file bankruptcy. We do have a rare case where people do it to play games with the association. And every couple of years, the association will file a lawsuit, and bam, they file for bankruptcy. I don't recommend it. It's gonna, ruin your credit and ruin your life, but we do have owners that actually do it. So that's something to consider if people do threaten bankruptcy. Think about, okay, we might not be able to collect on this. Foreclosure. Foreclosure is a hot topic right now in Arizona especially. I know AZ Central just covered a story on it. I know the news has been covering stories about homeowners association foreclosing. People have been acting like it's not something associations have always been able to do, but you have. In Arizona, under Arizona law, an association can foreclose if somebody has gone for a period of 1 year without paying their assessments, or if they owe $1,200 in assessments, whichever occurs first. If you're an association that has assessments that, let's say, I've seen some that are $50, $40, it's going to take you quite a while to get to $1,200. So that's why there's that either or, where you're going to have some people. I've seen very low assessments, and even in a year or two, they don't get to $1,200, but you have somebody who's just living there and draining the association, not paying. That's why that year period is also there, so that you can act if they haven't paid in a year. Some associations are really gung-ho about this. Once that year hits or once that $1,200 is there, they're ready to go and they're ready to file. Some wait a long time. It usually weighs on boards a little bit to proceed with foreclosure to see, to possibly potentially take away somebody's home. Again, with foreclosures, we're seeing a lot more people respond right away. Our office always posts a notice of foreclosure, so we let them know, hey, the association is intending to foreclose on your property. We give them 31 days to pay the amount. We've had a lot of people contact us and either pay the amounts owed in full, or they'll try to work out a payment agreement. So again, it's effective. What happens in the foreclosure is the association obtains a judgment against the owner, which orders the sheriff to sell the lot at a deficiency judgment. And the proceeds from that, if a third party buys it, the proceeds from that go to pay the association the amounts they were awarded in the judgment, which is great. It's a great way to make sure that the association gets paid. Usually you get a new owner in there too, which is really helpful, somebody who will more likely pay than the person in the property. I've seen some owners that I actually had one who didn't think this was possible. So she didn't pay her association for about 8 years. Yeah, and I think she ended up owing, they had some pretty pricey assessments. So by the time we moved forward with foreclosure, she owed about $9,000 to the association. And so I get a phone call from her after she served, and she tells me that it's illegal and I can't do this to her. And I said, no, if the association can do this. She goes, no, 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 my mortgage can foreclose on me, not my homeowners association. And I had to tell her, oh, no, 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 that is not the case. Your association can absolutely foreclose on you. And I realized that she had gone 8 years without paying because she thought the association couldn't do anything to her. She thought that she could completely get away with not paying this debt that she agreed to pay because she thought that the association had no bite to it. It's a really good example of why it's really important to enforce your governing documents, because that woman actually, I mean, she was claiming she was going to file bankruptcy. It was such a hassle to try to get her to pay. She finally did pay the amounts, but it was such a process for the association. It was such a headache for the board. That's why you want to move forward and you want to make sure that you are enforcing your governing documents and people do receive letters notifying them that they owe money or that they are in violation, because then later on down the road it doesn't get to a point where they say, well, nothing's ever happened before, why would I pay them now? Yes, someone's in the back, raise their hand. Yes, that's a very good point. So it depends on what happens at a sheriff's sale. So if the association does obtain a foreclosure judgment, usually what happens is the people who attend a sheriff's sale, they're there very regularly. They make it their job. They buy these houses and they flip them. I see a lot of regulars at these sales. If the property has equity in it, it sells very quickly to a third party, usually for much more than the amount that the association was awarded in a judgment. I would say on average, the average foreclosure judgment ends up being around maybe from like $5,000 to $10,000. So that's what the association is going to get. So if there's equity in the property and it sells at the sheriff's sale to a third party, I was just at a sale where the property, oh my gosh, what was it? They owed, I think, maybe $6,000 to the association, and the property sold for $125,000. The association doesn't get that $125,000, don't get too excited, but the association definitely gets paid what's owed to it. And then they can, if there's no equity, they don't have to pay the mortgage. If there is equity, if there isn't equity, usually that money is going to go to cover whatever is left of the mortgage. There is a chance, and sometimes associations do make this decision. We have had boards that just can't handle it anymore. This homeowner is problematic, or they're not paying, they've never paid, and they decide that, you know what, it makes more financial sense for us to get a new owner in here who's going to start making payments rather than let this person live here and not pay the association. So they make a decision, they make a call. We let them know, this is what we think is owed on the property. This is what the original deed of trust was for. And they say, okay, even if there isn't equity, we want to foreclose. And at a sheriff's sale, it might not sell to a third party. It might revert back to the association. But what normally happens then is if the owner has been remitting payment to the mortgage company, usually they'll foreclose in what's called a trustee sale. And then they take title of the property and they sell it off. So you're right. Your lien, the association's lien, is second to a deed of trust, but that's the only person that you're second to. You come before every other lien, every other debt, which is really, really helpful and important to the association. Okay, so the benefits of foreclosure of an assessment lien. Assuming it's successful, delinquent owner no longer owns the property after the sheriff's sale, and they can be evicted after the statutory time period. Usually it's 6 months. It's 30 days if a lot is abandoned. So if you do have a home that's abandoned, you can move forward with that process pretty quickly. Usually it's 6 months. It's called a redemption period. So once the property sells at a sheriff's sale, the owner then has 6 months to pay. If it's a third party who purchased the property, they have to pay whatever the third party paid. If the association ends up buying it back, they have to pay whatever the association paid. But they need to pay the purchaser for the property. It's rare that it happens. I mean, really rare. I don't think I've ever seen somebody redeem the property in the entire time that I've had this job. The delinquent owner may attempt to settle. Like I said, people want to keep their houses. I know it's shocking, but they do. And they'll really work to try to save their home, to try to reach a payment agreement. And again, it really demonstrates to owners that think that the board and the governing documents have no bite, that yes, the board is going to enforce these documents and you owe this amount, and the board has the mechanisms to make that happen, to make sure that you pay those amounts. If the property is sold to a third party at the sheriff's sale for an amount that exceeds the judgment, like I said, the association will recover the full amount owed to the association. That's our best case scenario. And it happens more often than not. Usually, we make sure that when we're looking at a property that could potentially be foreclosed on, our office does an evaluation and says, okay, do we think there's equity? Do we think there's equity in the property and that the association is going to recoup their fees? Again, we want to be smart about collecting assessments and collecting amounts owed, so we need to think about what's the best case scenario for the association, what could happen if the owner answers, and does the owner have the money to potentially pay this? I just need to check the time, I realized. Oh, we're close to being done, sorry. So disadvantages, always important to know. So the estimated legal cost and court cost for a foreclosure action are approximately $1,500 to $2,500. It can be more if the owner answers. Sometimes owners file answers or they hire their own attorney, and then your attorney is required to respond and deal with that issue. So it can be more. They can be more than that. That's the average cost. So it's definitely pricier than the Department of Real Estate. It's definitely pricier than your justice court lawsuit. It takes about 6 months to a year from the date of filing the lawsuit to the sheriff's sale of a lot. It's quite a process to get it done. I think usually it's worth it in the end, but you need to know that you're in it for the long haul with that kind of lawsuit. Again, if an owner files for bankruptcy, everything will be halted. Sheriff's sale, judgment, anything. You can't collect on anything until the bankruptcy court either dismisses the case or they may discharge the debt that's owed. It just depends on what the court decides to do. If the delinquent owner stops paying the mortgage, the first deed of trust could foreclose before the association and wipe out the association's lien. So that's what you were talking about. Sometimes we do get first deeds of trust that beat us to it. We filed a lawsuit and they get to the point where they're just as fed up as the association and they file a trustee sale. They will wipe out the association's lien. They take precedent under state law. If a delinquent owner pays the full amount owed to the association as per the judgment within this 30 days or 6 months, after the sheriff's sale, she can redeem the property. We covered that. So be aware that if you're trying to get rid of somebody that you really don't like, be aware that they can still buy it back and you might be stuck with them after that. So I was mentioning this earlier. We strongly recommend if you decide to try to do this on your own, which you'll hire an attorney to do it, but make sure you look at the credit history of the owner. You would be actually very shocked what you can find by doing a general Google search, Facebook, LinkedIn. We can find a lot of information on there. Look for the status of the first deed of trust. The Maricopa County Recorder site is going to have the first deed of trust, so you're going to know how much they paid for the property. And then you can kind of figure out, okay, do they have a 30-year mortgage? How much are they paying every month? Do you think they're paying? Where should they be at in the amounts owed? And are they at those amounts? So again, being smart about how you collect the money, making sure that you're going after or enforcing the documents in a way that makes sense for the association. Because I've seen some boards that get really fixated on a homeowner. They're problematic, they never pay, or they pay in spurts. And they get really fixated and they just want to get the money from the homeowner. And sometimes our office has to tell them to take a step back and say, okay, do you think you're going to collect money from this person realistically? Like, these are your options. This is what we know. This might not happen the way that the board thinks it's going to happen. So be smart about how you're collecting money. Take the time to really think it through. Oh, so our secrets for collecting delinquent assessments. Adopt and strictly enforce a collection policy. Yes, you would be shocked how effective this is. Actually send them letters, notify people that they owe money. If they know that they're going to get a letter, if they're 15 days late, 20 days late, if they know they're going to get the letter, they're going to be a lot more likely to pay. And also, if you do that, more, like I said, more homeowners are going to pay, and then you'll be a lot more in tune to who can pay, who really can pay, has the money, and who may be struggling, and who the board maybe needs to make an agreement with. you are just much more likely to collect everything if they know a letter or an email is going to follow. If an assessment is 60 to 90 days past due, record a lien. Again, we found them to be so effective, especially as the economy gets better. People are flipping their houses, they're refinancing, they're selling their houses, and that lien causes a lot of problems for them, and it also just affects your credit score in general, so they want them removed, they want to pay them. And you want to get it at a point when it's easier for the owner to pay off. It's hard when associations, like the one that I said didn't collect for 8 years, all of a sudden this owner had this lien for $8,000 and she didn't have $8,000. If you start early, and I'm not saying when they owe a penny, but if they owe a couple hundred, file a lien. It's a lot easier for them to figure out how to get you that money as opposed to thousands and thousands of dollars, which is what some associations do. If the documents provide, you can suspend the owner's privileges. We discussed that earlier. It's pretty effective. Request that all the lots or unit owners complete an owner information sheet, including their name, their employment, their mortgage company, and their bank account numbers. You don't necessarily they don't have to provide this to you. I mean, how many of you would really give out your bank account number to your homeowners association? But you'd be surprised, and also it just lets the homeowners know that the association is serious about collecting their assessments, that they owe the assessments just like they owe their mortgage payment, and they need to be aware of that, and they need to treat it like it's a mortgage payment. Understand the legal remedies. That's why you're all here. You're doing a great job understanding the legal remedies, so kudos, check mark, you've done that. Use open and continuous communication, newsletters, demand letters, with the owners regarding the need for timely payments of assessments and the procedures the association will follow. If you do have a lot of people that suddenly, so Christmas is coming up, sometimes people decide between presents or a payment, or just in the shuffle of the holidays, they forget to submit their assessment payment, send out a letter and let people know, reminder, your assessments are due on the 1st of the month, or we've had a lot of late payments lately. If you're struggling, contact the board. The board does want to be firm with your policy, but you also want to appear open to working with the homeowners so that they know that they have the option if they are struggling, if there is a problem, that they can come to you and work something out, as opposed to creating this kind of antagonistic relationship between someone who's always in debt with the association and an association that's always trying to collect on somebody. It's usually just more effective than that antagonistic relationship. Make copies of all the delinquent owners' checks. So this is helpful for bank garnishments. There are a lot of associations that don't do this, and they don't claim that when they get to our office and we get a judgment, we say, okay, let's try a bank garnishment. And we say, did they pay with checks? Yeah, where are the checks? We don't know. I'm like, okay, well, you have the information right there. You can collect, you have this legal remedy, and because you don't know where the checks are, because you haven't taken the time to copy them, you don't have that option anymore. And again, nobody's going to give you their bank information, so trust me, I've tried to ask owners. I've told them, under the law, you have to give me this information, and they say absolutely not. So the check is the best way to go about getting that information. If you're notified that an owner has filed for bankruptcy or trustee sale, contact your attorney immediately. You need to figure out if your lien is going to be wiped out, if the owner has filed Chapter 7 or Chapter 13 bankruptcy, if you need to put a stay on any collection efforts. Contact somebody right away, just so you make sure that you're not violating any possible federal laws regarding debt collection. Once a collection file has been turned over to attorney, allow the attorney to handle all communications with the debtor. That's just safe because the attorney is going to be a little bit more forceful, a little bit, they're going to inspire a little bit more fear in the owner, and the owner is going to realize that they need to listen to the attorney and they need to remit payment as soon as possible. Sometimes we've had boards that they want to talk to the owner and then they make deals with them and they don't tell our office, and then they say, well, they were supposed to pay 3 months ago and they didn't pay, and we'll say, okay, well, why'd you turn it over to us then? Just let us communicate with them. And usually, honestly, sometimes just getting a letter from an attorney, just that attorney letterhead is enough to kind of jolt people into paying. So let the attorney do what they're doing if you do decide to send your files over to an attorney. So that was my spiel on collecting assessments. Does anybody have questions about that before I move on to the parking lot questions? Yes?
Yeah, this involves in our CCNRs, we have a language that says if you're delinquent, then your right to vote at a removal meeting or election meeting is denied. However, when dues are due on the first of the month, you have 30 days window to pay before it's considered delinquent.
Okay.
We just removed the entire board.
Oh, wow.
And what happened at that removal meeting was one resident was denied the right to vote because they said she owed 36 cents in assessment. She opted to pay cash, and the attorney present there said, no, we can't accept it. And I said, well, go see the manager. I was behind the lady. I said, go see the manager, talk to her. She went and talked to her, the manager refused to take 36 cents. As a result, the woman was denied the right to vote. That was a removal meeting. 30 days later, we had the election of the new board. This time, many people were denied the right to vote because they paid like the 15th of the month, the 17th of the month, within that 30-day window. They were denied the right to vote because the board arbitrarily selected the 15th of the month to be a cutoff date that would generate a list of eligible voters, but never told any of the residents who were mailing or e-blast or anything. So then another handful of people, it was seen to be a move to keep people from voting. So do they have that right to do that?
So it depends on exactly what your governing documents say. Usually, yes, the board does have the right. If there are provisions in your governing documents that say that if an owner owes money, especially if they don't specify an amount, if you owe an assessment amount, technically can the board say you owe 36 cents, you can't vote? Yes. Should they? No. Especially if somebody is offering your 36 cents. I'm pretty sure I have that in the bottom of my purse. You know, it's about being reasonable, about the board being reasonable. But boards can handle that how they choose. So they can, it's your responsibility as an owner to make sure that you pay your assessments. If you really are delinquent and the board is trying to figure out who is delinquent a couple of days before the vote, they're not required to notify you that you can't vote. You were supposed to have read the governing documents and have known that that's the case. Your situation is a little bit different because you have this 30-day provision. So if people really didn't pay, you know, let's say 15 days beforehand, I would look into that and see, you know, okay, when was this assessment due? If for 15 days, they're not technically late. So I would say read the provisions very carefully, make sure you're looking at the exact language. The board does have the right generally, if they have that language, to stop somebody from voting, but we always preach reasonableness. So for example, I have a board that's, a lot of you I'm sure are having your annual meeting soon and you're having elections coming up. And they asked me about it and they said, we only have 2 owners that aren't current on their assessments. You know, what should we do? And I told them, notify them. I mean, I would be mad if my right to vote was taken away. So you want to notify them, give them the chance to pay. That way, if they do eventually get upset, if the owner does eventually say, hey, I wasn't allowed to vote, you can say, you received this letter, you were notified that this was the policy, we asked you to remit payment. But obviously the board should do that, you know, within reason. 36 cents is a little crazy. Yeah.
Can I recommend that you take the parking lot
Sure.
items back with you and then maybe provide a written response?
We can definitely do that.
That Ruby can then copy off of
Okay,
the
that's
class.
perfect.
Since we're already 15, 20 over.
You guys, I am so sorry.
Just so that, because I know that some of these are very specific questions, just so that it's not of the interest.
We'll have Ruby send it out. I'm so sorry, everybody. Thank you so much for listening to me. Thanks for coming out tonight.
The evaluations and the RC that you can take
Also for everybody, our firm does a service called First Friday, where the first Friday of every month from 9 to 10 a.m., you can call in and ask us a free legal question. Usually it's a pretty simple one, but it's next Friday, so if you want to call in and ask us a question, feel free to do so. Thank you so much for coming out.